2 days time is granted to do the needful. In the event needful is not done in the next,
Already served the complainant. my lord.
Learned Council seeks 2 days time to do the needful. Place the matter on 31st. Interim order subsisting shall continue to the next date.
341, 323. Last time, Lordships had directed for investigation papers to be summoned.
Please, my lord.
Ready? The complaint was registered against unknown persons.
Unknown.
How did you get to know it is these people?
My lord, the vehicle number has been mentioned in the complaint, my lord, by virtue of that may.
Oh, vehicle number mentioned ಮಾಡಿದ.
It was my aunt's own vehicle.
Your aunt's vehicle.
Yes, the petitioner's aunt's.
Wound certificate ಯಾರ್ದಿದು? The victim?
Please, my lord. Simple in nature.
It's all right. Why did you block them? Block the petition?
Notes, what happened was
Block the
narration-
complainant.
Yes, notes, even the complaint also he says, he completely goes on honking, the respondent number 2 complainant. He does not leave. These people just get down to ask with him, what is it, notes? And then, notes, there was
Who gets down to ask?
the petitioner number 1 and 2, notes. There are 3 petitioners.
To ask what?
But because he was hurling abuses at them verbally. In fact, I was told, no, in fact, I was told,
Who was hurling
the
abuse?
respondent number 2 complainant, Millards, while he was honking,
Huh.
and while they stopped next to each other, he lowers the window and starts abusing them verbally, even taking mother's name and all the swearing words. These people get down to ask him, why are you behaving so aggressively? But then, no, but this is what has happened. In fact, a lot of sees, even the ingredients of 341 under the complaint is an oversight. He writes in different handwriting.
41 you lived.
Yes, even 3.
Because these instances are on the rise.
I understand, but all petitions, all in early 20s, even the
Only
complaint.
20s ಮಾಡ್ತೀರಾ guys?
That's what I'm saying.
That's what they're indulging in.
No, in fact, we did not lodge a complaint. That was a mistake, I also told them, because it was cross complaint. This is a case for cross complaint. It is not a voluntarily that this matter happened. It was provocation, and they had a verbal abuse. Is what given to understand. Therefore, in fact, my petition number 3 never even stepped out of the car. When allegation is against him as well. They're all working now, just joined job, employment. This would lead to difficulty in their employment as well. Petition number 3 is student milots.
You hit the complainant through the window.
The allegation is all 3 of them hit him. You do not understand how one window where he is sitting, all 3 of them can assault like that.
Why?
It's physically 3 men standing outside of one window and hitting is far from truth. What they have done, in fact, not
Why 3 men can't hit
what I
together
said.
on a
The
window?
practical part of it, when a driver is sitting and in one window 3 people come. As I submitted this petition, I made an amendment in my petition as well. Petition number 3 even never stepped out of the car. He was not involved. It was a scuffle. I do not disagree. There was no altercation. It was a scuffle, which is no physical abuse as such, which is made out to be. And in fact, next morning he goes and gives a complaint. And I'm told the wound certificate. I'm not aware. That's what is.
Yes.
Yes. May I have a benefit of having a look at it? I've not had.
Investigation. You will get it at the time of trial.
It's my
Final report hakli. Such instances.
Because if 341 does not stand, we will kindly have a look at
341
the.
also stands.
Your Lordships may see the way it is made out in the complaint. It's an afterthought.
Complaint.
It's an afterthought, Millards.
ಯಾವುದು ಹೆನ್ನೂರು ಬಾನಸವಾಡಿ ರೋಡ್ ಇದು?
Yes, Millards, that junction. They live in that vicinity, Millards, the petitioners.
These I told you, these instances in the wee hours of the night
But there's no physical assault, Millards.
have become rampant.
I understand, Millards. I do not disagree with that. But there's no physical assault as such.
Road rage, overtaking, stopping, hitting the glass. Get some kind of kick in this. Young students.
In fact, notes they try, I mean, both of them have spoken to each other, also respond number 2. Next, we did not lodge a complaint, that's all, that's only missing
You should have
element
lodged
in
if
this.
there was some
Yes.
altercation
It
or
was,
stuff.
Lords, it was
You
indeed.
should have
Lords.
lodged a
Yes, that
complaint.
is the thing, Lords, here.
That's anything else?
I only say petition number 3, my lords, admittedly wasn't there. That part of, if I could see the investigation papers, my lords.
He was not there
And-
under Karl Kotidra.
Yes, he never stepped out, my lords. None of the allegations will be made out against him. Prima facie is what my submission is, my lords.
Yes. Best, let investigation continue. I'm not staying it.
Lords, may I in that case withdraw the petition, lords, instead of suffering an order at your
And
hand?
present it after the final report is filed.
Please, with the liberty to challenge it. Yes.
Learned counsel for the petitioner, after arguing the matter at length, seeks leave of this court to withdraw the petition and approach the appropriate fora once the final report is filed. Reserving such liberty, the petition stands disposed as withdrawn.
Great.
वापस करो.
43.
Copy ಸರ್ವ ನಾನು acknowledgements ಬಿಡಿಸ್ತೀನಿ.
ಮಾಡಿದ್ದೀರಾ? ನೋಡೋಣ. Tuesday happen, but Wednesday list on 28th in the fresh matters list. Next. Yes, comment?
54.
But we already have a benefit of the order of this honorable court itself, but where
Page.
pre-criteria is, my lord,
Page,
can you come to
page.
page 42?
Ah,
Pre-criteria is that it has to be a forest land and that I have to encroach it. Now, my lords, may kindly come to page 44 itself in the order, where it records that, my lord, says the entire land is 22 acres. This is just one portion of the 22 acres, where there was an order passed by the special deputy commissioner, changing mutation entries, my lord. Now, that was declared as a mini forest. That has been quashed. If my lords were to kindly see page 44, the second paragraph.
your land also comes within that
Yes, my lord. This is my order itself.
or order.
My lord, in the sense, I'm the petitioner in this, my lord. It is. so
Abraham,
Penelope Abraham is the owner of the property, my lord. We are workers. We are employees of hers,
employees of,
of Penelope Abraham.
where do you say so?
Lord, my petition, that's my entire case, my lord, because the land belongs to Dr. Abraham, and my lord, I'm her employee.
Heard the learned counsel appearing for the petitioner. The learned counsel takes this court through an order passed by the coordinated bench in writ petition 29798 of 2013, disposed on 24th June 2023, declaring that the land that belonged to Dr. Penelope Abraham, page 42, Abraham is held to be a land which does not belong to the forest. The petitioners claim that they are employees of Penelope Abraham. In that light, there shall be an interim order of stay of further proceedings where these petitioners till the next date of hearing. Learned HCGP is HCGP is directed to accept notice for the respondent. Next.
Great.
55.
My lordship, petitioner is accused number 2, my lordship.
Yes.
The offense under section 20 of
Co-accused
the-
statement.
Yes, my
No
lord.
other,
Then
no other corroboration.
Other,
The petitioner is accused number 2, who is alleged of offense punishable under section 20B of the Narcotic Drugs and Psychotropic Substances Act 1985. The contention of the learned counsel appearing for the petitioner is that he is roped in as an accused only on the confession statement of accused number 1. The perusal at the records and the statements would also indicate that there is no corroborative material other than the confession statement of accused number 1 to pin down the accused number 2, the present petitioner. Therefore, there shall be an interim order of stay for the proceedings where the petitioner till the next date of hearing. Yes, next.
46.